today we are taking a look at the attorney sanctions because one of them is 69 pages long and it's full of sidebar transcripts. It's October 14th. We just covered the Cardi B trial. There is a sanction hearing set for Friday this week, October 17th, in the post-trial litigation of the Cardi B case. And that is with regard to the things that went down during trial with plaintiff's counsel. But the only way we're going to get a full feel for the plaintiff's attorney is to take a look back at a time oh so long ago in 2023 when this same attorney seems to have caused a mistrial by getting into a physical altercation with other attorneys. Girardi's mistrial linked to alleged attorney hallway altercation. A California state judge declared a mistrial Monday. This is from July 10th, 2023. Declared a mistrial Monday in a contentious legal malpractice case over allegations that Girardi botched a medical malpractice suit. An outcome that a Girardi attorney attributed to a purported physical altercation between lawyers in the hallway outside court last week. It wasn't immediately clear in open court why Los Angeles Superior Court Judge Mel Red Ricana declared a mistrial in the case, as he didn't explain his reasons ahead of the decision. But Girardi's attorney, Alexandria Kazarian, told Law 360 that the mistrial involved a purported physical altercation allegedly initiated by the plaintiff's attorney against a defense attorney in the hallway outside the courtroom at the end of the day Friday, which some jurors may have observed. The attorney who was in the closed-door discussion after the Friday altercation told Law 360 that the trial was an abomination, and it appears that this was calculated and engineered by the plaintiff's side for the purposes of getting a mistrial. That is a huge allegation. The allegation is this trial's bullshit. They were going to lose, so they suspect and allege that the plaintiff's attorney, same plaintiff's attorney in the Cardi B case, calculated this to cause a mistrial. Plaintiff's attorney Ron Rosen denied Kazarian's characterization of a physical altercation and rejected her quoted statement to Law 360 as false. Kazarian told Law 360 that the judge said the state bar would be informed of the incident and referenced a recently approved rule, the new snitch rule, the post-Girardi snitch rule, which requires lawyers who have credible evidence that an attorney is engaging in misconduct to report it to the bar. California was one of the few states that did not require attorneys to tell on one another. They added that rule after the Girardi, all the things. So that was the beginning of the mistrial of the malpractice lawsuit due to the attorney scuffle. Now, 2 days after that article, July 12th, we get a more in-depth article. Girardi's judge told of schoolyard-style attorney altercation. Attorneys for Girardi and counsel for a family suing the firm for malpractice laid out competing accounts Wednesday of a courthouse altercation that led to a mistrial, with a defense attorney alleging that plaintiff's counsel knocked off his colleagues' glasses and stomped on them, while the plaintiff's counsel were called a purely verbal spat. Girardi's attorney, Kazarian, told Law 360 that the mistrial was prompted by a purported physical altercation Friday initiated by plaintiff's attorney Ron against Steve Belyaev. So Steve's co-counsel, Steve, told Judge Ricana that he personally witnessed the altercation and said it was initiated by Ron. He said he witnessed Ron approach Belyaev, Steve, quote, in a very aggressive manner and called him a bitch and said, "Do you want to get a piece of me now?" In the hallway of the court, the attorney whose closing argument was, Cardi B cursed, is approaching opposing counsel, calling him a bitch and saying, "Do you want to get a piece of me now?" So then Steve says that Ron spun Belyaev, the other Steve, around during the altercation and knocked Steve's glasses to the ground, Segura told the judge. Segura said he also witnessed Ron walk over to the ground where Steve's glasses landed and intentionally stomped and kicked them. Then, as soon as sheriff's deputies came into the hallway, Ron started accusing Steve of the contact. Oh, so the second the sheriffs show up, he's like, he did it. Based on everything we've seen in court, I 100% believe it. Meanwhile, Ron maintained this was nothing more than a verbal argument between counsel. Ron goes on to say, the only thing I did here is one of the jurors said that Steve struck me. The attorney further argued that if opposing counsel continues to, quote, push the issue, then I'll have all the witnesses confirm what he did to me. And I'll leave it at that. Wednesday's hearing stems from Ron's ex parte motion, which means just to the court. Ex parte motion filed Tuesday urging Judge Rocana to reverse his decision to recuse himself from the case after the mistrial was declared. Ron wrote in the filing that he and his clients have great respect for the judge and want him to continue presiding over the case. On Wednesday, Ron said he's hired private counsel since the incident and implored the judge not to report him to the state bar, claiming that, quote, he did research on the new reporting rule, spoke with a state bar attorney, and the rule doesn't go into effect until August. He also claimed that the state bar's reporting requirement doesn't apply to judges. Quote, I'd ask there be a lesser sanction of some sort if the court wants to, Ron said to the judge. Quote, there's no reporting requirement. You don't have to recuse yourself. And I'm going to say it. You're my favorite judge in the entire courthouse. That's what it is. And the plaintiffs feel the same way. And they want you to be the judge on the case. Ron urged the judge to consider the personal impact on reporting him to the state bar. I'm a young attorney. I'm 47 years old. I have time to get married and have children, and I don't want my reputation tarnished. You're going to try to make the judge feel guilty for reporting you to the state bar for your own behavior. Your Honor, think about the damage it will do to my career. Well, you should have thought about that before you allegedly put hands on people. Filed October 2nd, 2025, ahead of the hearing scheduled for Friday, October 17th. This is in the Imani Ellis Cardi B case. Post-trial litigation, the lawyers are fighting, though this time not physically, just with their words. Declaration of Peter Anderson. Mr. Anderson is Cardi B's attorney. Ron is the attorney for plaintiff in this case, Ms. Ellis. Peter Anderson says, I am an attorney. I am an attorney with this law firm. I defended Cardi B in this action. If called as a witness, I would testify to what follows. Violations of motions in limine order. Count 1. Cardi B's pretrial motions in limine included her motion in limine number 1, filed July 1st, 2025, seeking an order precluding plaintiff, Ms. Ellis and Ron, her attorneys, from referencing to, arguing, or introducing any other evidence at trial regarding any former association with a gang or gang members during her youth. And then they cite the motion in limine. On July 30th, the court granted that motion in limine, concluding that any references during the trial to Cardi B's, quote, prior acts and alleged prior acts, as well as any prior involvement in exotic dancing or any gang associations that have no apparent probative value, and any references thereto would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. So the court said no. On August 26th, Ron began his direct examination of Cardi B by asking,
do you have any affiliation at this time with a gang?
Objection, Your Honor. Motion limiting that violates the motion limiting the order.
Ron argued that he did not violate the court's order number 1 because the order only prevented him from asking Cardi B whether she used to have gang affiliation and not whether she is presently affiliated with a gang. Improper closing argument. I've never seen so many sustained objections in a closing. As raised in the accompanying memorandum P&A prior to closing argument, the court admonished Mr. Ron, not to argue facts not in evidence. This is well known. You shouldn't have to tell a lawyer, hey, by the way, rules. Yet, Ron proceeded to do just that. I mean, they knew what was coming, right? In his closing argument, Ron made appeals to jurors' sympathies and biases, misrepresented the evidence, expressed his personal opinion, and claimed knowledge of a disputed fact. Indeed, in apparently less than an hour of closing argument, the court sustained 18 objections, averaging approximately 1 sustained objection every 3 minutes. I love that they counted. In closing, count 25. Ron argued that Cardi B has anger management problems, which was not supported by the evidence and also violated the court's in limine order by arguing character and suggested prior bad acts.
Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
25 different counts. And these are all of the transcript snips regarding this. This is the court talking about it. Ron, yes, Your Honor, my argument is that, and I've consulted with other lawyers about this, and everybody's pretty much in the same path of if the psych claim goes away, then those 3 doctors go away. It just wouldn't make sense. I'm not going to give up my claims and then have the doctors testify. That's my argument. If they're going to have these doctors testify, we'll just keep them and roll with it. The court, again, I don't want to rule in a vacuum, but it does seem to me, one, that the statements that were made to the doctors that could potentially impeach or contradict plaintiff's own testimony, that is likely to come in. And 2, if there's a doctor that says she suffered no emotional distress, whether it's garden variety or not, that seems to be relevant. Ron, I guess I'll have to think about it then. The court, all right. The sanctions available to the court. Ron's choice, and again, he is referred to as Mr. Rosen in all of this. I have shortened it to Ron. Ron's choice to disregard the court's orders in limine and argue facts outside the record after the court's express admonition not to do so implicates the court's contempt power. The court may issue an OSC directing Ron to explain, if he can, why he should not be held in contempt under the civil code. I think the court will do that. I think the court will grant an OSC and say, explain yourself. On a finding of contempt, penal sanctions may include fines up to $1,000 per violation. Do you see where this is going? There are 25 instances. Why don't you just sanction him $25,000? When contempt stems from violations of court orders, the court may additionally order fees paid to the party initiating the contempt. Sanction him $25,000, Your Honor, and then give us attorney's fees on top of it. Cardi B identifies at least 25 distinct violations by Ron of the court's orders in limine, order from the bench prohibiting argument of facts not in evidence, which is also just the rules of evidence, and establish principles as to proper and improper closing argument. Ron's misconduct was egregious, persistent, and included both calculated attempts to do end run around the court's orders and unequivocal misrepresentations of the evidence to the jury. Despite multiple sustained objections, warnings, admonitions, he persisted, made no effort to mitigate, and continued the same misconduct through closing. Deterrence is necessary and appropriate. Your Honor, he is a menace. Conclusion. Accordingly, Cardi B respectfully requests the court issue an order directing Ron to show cause why he should not be held in contempt and sanctioned. This is the October 3rd response from attorney for plaintiff Amani Ellis, Ron's response. Ron's response is an application for issuance of an order to show cause regarding Mr. Anderson's trial misconduct. To the Honorable Court, Plaintiff Counsel Ron A. Rosen Janfaza, Esquire, is extremely disappointed that defendant would present an application for issuance of OSC regarding trial misconduct when defendant made it clear that the parties would be walking their separate ways. This is not EDB hyperbole. I am not exaggerating. That is exactly verbatim what that first sentence says. Plaintiff's counsel is not a quote unquote seasoned trial attorney. I am reading from his own motion, y'all. It doesn't matter. You have a law license. You have to adhere to the rules. Also, in 2023, you were crying to the court that you were a young attorney at 47 years old, but you've been a member of the bar for over 20 years. Counsel is not a seasoned trial attorney and did not intentionally, okay, Sarah Boone, did not intentionally attempt to violate any court orders. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial, which lasted from August 25th, 2025 to September 2nd, 2025. Plaintiff counsel's law license is the most important thing to him. If you are listening in the background, I am reading this verbatim, which he would never sacrifice for any reason. Plaintiff's counsel previously proceeded to trial in approximately 10 different cases. I mean, I guess you're not going to trial very much, but that's not brand new. And in one of them, you managed to get sanctioned at least $20,000 and get a trial mistried for fighting with opposing counsel. I would say it's a storied record at this point. Plaintiff's counsel respectfully applies to the court for an issuance of an order directing defense counsel, Mr. Anderson, to show cause why he should not be sanctioned or held in contempt for his trial misconduct, including violations of court orders and the California rules of professional responsibility. I know you are, but what am I? Ron goes on to say that Mr. Anderson violated California rules of professional conduct 3.10, threatening criminal, administrative, or disciplinary charges. Defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the court of the trial, that he would report him to the state bar. To add insult to injury, he says, on September 2nd, defendant threw a pen at a man outside the Alhambra courthouse. Defendant Cardi B? The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. And it was also completely unlawful and disrespectful. He said it was disrespectful for the defendant to injure others during the trial on the Alhambra courthouse property, which she did on September 2nd. I'm sorry, September 2nd is verdict day. That's not during the trial. The trial was over. This is not the defendant's first time injuring others. Oh, so you're not answering the charges at all. This is not defendant's first time injuring others, he says. In July 2023, defendant physically threw a microphone at a concert goer at Dry's Beach Club in Las Vegas, Nevada, who was injured. Excuse me, counsel, wasn't it July 2023 when you put your hands on opposing counsel and stomped on his glasses, causing a mistrial in Judge Rakana's court? That you? He goes on to say, plaintiff's counsel is limited in his ability to provide additional information at this time, as he is represented by counsel for defense counsel's wrongful conduct. Your Honor, I have a lawyer. Plaintiff's counsel nonetheless submits this application in good faith, so the court is made fully aware of what transpired. They submitted transcripts, and you said, but Your Honor, Cardi B did shit. It's not relevant, counsel. So what did we learn today? Well, we went over plaintiff Amani Ellis' attorney's prior incident in a Garrigus and Garrigus suit, wherein a mistrial was declared because of an attorney altercation in the hallway between plaintiff's lawyer, Ron Rosen, and the attorney for the defendants. The defendants in that case were Garrigus and Garrigus and Mark Garrigos, because it was an attorney malpractice suit. The altercation of the attorneys in the hallway caused a mistrial of a civil lawsuit that had been going on for over 2 weeks. In that same civil lawsuit, attorney Ron Rosen was sanctioned over $22,000 for discovery violations. And now we have seen Cardi B's lawyers file 25 different counts of instances where they are asking for sanctions up to $1,000 per incident. Plus they are asking for lawyers' fees. Plus they're like, hey, Your Honor, you can find him in contempt of court, because while they are arguing numerous improper arguments in closing argument, they are also arguing that not only that, but there were multiple blatant violations of the motions in limine. And they listed out what the motion rulings were and then what the lawyer proceeded to do. And at the end of court, they said, we need to bring up the issue of sanctions. And the court said, I will set a sanction hearing. And the sanction hearing is set for October 17th. Is the court going to order Ron Rosen to explain? I think so. Could Cardi B's attorneys win lawyers' fees in this? Yes. Could he be found in contempt? Yes. Could he be sanctioned? Yes. Will this get reported to the state bar? Yes. What will the state bar do? Well, we'll see. The state bar doesn't comment on attorney discipline, and sometimes you will see it on their record, but oftentimes the state bar will deal with it without it ever showing on a lawyer's record. But in the case with the Girardi trial, and in this case, we have seen attorney Ron Rosen respond the same way. No, Your Honor, I didn't. My law license is important to me. And in this one, he actually argued, I'm not a seasoned trial attorney. He was admitted to the bar of California in 2004. First of all, once you're admitted to the bar, you have to follow the rules. And the court spelled it out numerous times, saying, I didn't know better isn't a defense. He also said that he has counsel, so I wonder if his lawyer will be filing anything ahead of the hearing on Friday. Sanctions will not be issued at that hearing on Friday. It's whether or not this will go forward for him to answer, and it might result in a hearing. Can you imagine if they put him on the stand under oath and literally are like, what were you thinking? But I don't think I've ever seen a lawyer say, Your Honor, I'm not a seasoned lawyer. I'm just a baby. I didn't know. Oh, and then he said, but Your Honor, the defense, Cardi B's lawyers, threatened to report me to the state bar. They should be sanctioned. Oh, and Cardi B, Your Honor, she's rude. He actually brought up in his motion that Cardi B threw a pen after trial and threw a microphone in 2023, he says. So instead of addressing the allegations against him and what opposing counsel said, he went back to attack Cardi B. So what's going to happen from here? Well, let's see if there's more filings. And if there are, we will absolutely be covering those filings. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you. And you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.